In the House, it's called the Protecting the Right to Organize Act. What it should be called is the Enforcing the Requirement to Organize Act. While they claim the act is to protect the right to organize, a look at the language of the bill shows that this is not about protecting the right to unionize, but forcing people to do so. Once again, we see the federal government illegally regulating employment, coercing people to join a collective, and doing all it can to destroy small business. So we'll take a look at that next on the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach Rising Generation Be Free. I'm glad you could join me today. Now, as always, you can find more information at the website constitutionstudy.com. You can find the text article of this, you can find other articles and all the stuff we're doing at the Constitution Study. I also hope you check out the Patriots program, but I'll talk a bit more about that at the end of the episode. For now, let's take a look at this Protecting the Right to Organize, or PRO Act. The Protecting the Right to Organize, or PRO Act, claims to amend the National Labor Relations Act, or the NLRA, to protect workers. Let's start at the beginning with the NLRA. The denial by some employers of the right of employees to organize and the refusal by some employers to accept the procedure of collective bargaining lead to strikes and other forms of industrial strife or unrest, which have the intent or necessary effect of burdening or obstructing commerce. Here, we see the first problem with the NLRA. Congress does not have the power to regulate commerce, only to regulate commerce with foreign nations and among the states and with the Indian tribes. That means the NLRA is unconstitutional and will therefore void. Those are not my words. They're the words of the Supreme Court in the case Norton v. Shelby County. An unconstitutional act is not a law. It confers no rights, it imposes no duties, it affords no protection, it creates no office. It is in legal contemplation as inoperative as though it had never been passed. While the NLRA lists several reasons why employees may wish to organize and collectively bargain, that doesn't mean Congress has the legal authority to regulate it. In fact, the Constitution strictly prohibits them from doing so. From the 10th Amendment we read, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people." Furthermore, the reasoning behind the NLRA is both self-serving and flawed. First, it claims that employees have the right to organize, which they do. But the Act completely ignores the rights of the employer to determine who they will employ and under what circumstances. While the employees can associate however they wish, they do not have the right to force employers to comply with their demands or to have the government join their side of the negotiations. Experience has proved that protection by law of the right of employees to organize and bargain collectively safeguards commerce from injury, impairment, or interruption, and promotes the flow of commerce by removing certain recognized sources of industrial strife and unrest, by encouraging practices fundamental to the friendly adjustment of industrial disputes arising out of differences as to wages, hours, or other working conditions, and by restoring equality of bargaining power between employers and employees. While Congress claims that experience has proven that these types of laws protecting the rights of employees to organize safeguards commerce, government regulation tends to destroy commerce in red tape, regulations, and political agendas. Before you think that Congress was completely one-sided when it decided to draft the NLRA, it wasn't simply to protect employees from business. Experience has further demonstrated that certain practices by some labor organizations, their officers and members, have the intent or the necessary effect of burdening or obstructing commerce by preventing the free flow of goods in such commerce through strikes and other forms of industrial unrest, or through concerted activities which impair the interests of the public in the free flow of such commerce. The elimination of such practices is a necessary condition for the assurance of the rights herein guaranteed. Congress keeps referring to experience proving something, but they never actually point to any experience to prove their point. Yes, there's been a lot of history of strikes by labor, but they didn't stop with the passage of the NLRA. It is hereby declared to be the policy of the United States to eliminate the causes of certain substantial obstructions to the free flow of commerce and to mitigate and eliminate these obstructions when they have occurred by encouraging the practice and procedure of collective bargaining and by protecting the exercise by workers of full freedom of association, self-organization, and designation of representatives of their own choosing for the purpose of negotiating the terms and conditions of their employment or other mutual aid or protection. It may be the policy of the United States to eliminate the causes of disruption to the free flow of commerce, but it's not a legal one. Experience has shown us that rarely does congressional meddling in things they are not legally allowed to improve the situation. Instead, it usually makes things worse. Take, for example, the Affordable Care Act, the Social Security Act, the Patriot Act, and even the Inflation Reduction Act. Not only have all these pieces of legislation claimed to protect Americans, but in the long run, they've made things worse. Worse yet, all of them are outside of the powers delegated to the United States and therefore void. So if the NLRA is unconstitutional and therefore no law at all, any amendments to it would be, at best, putting lipstick on a pig. Sadly, the PRO Act is far worse than that. Probably the most onerous parts of the so-called PRO Act is the idea that Congress gets to define who is and isn't an employee. Section 2(3) of the National Labor Relations Act is amended by adding at the end the following. An individual performing any service shall be considered an employee, except as provided in the previous sentence, and not an independent contractor unless the individual is free from control and direction in connection with the performance of the service, both under the contract for the performance of the service and in fact. The service is performed outside the usual course of the business of the employer, and the individual is customarily engaged in an independently established trade, occupation, profession, or business of the same nature as that involved in the service performed. Rather than protecting the right to organize, this act starts by depriving the right of the people to work independently. The law basically says that you're an employee unless the government says you are not one. California tried this already with AB 5, which took effect in January 2020. AB 5 was an attempt by California to regulate companies like Uber and Lyft that hire large numbers of so-called gig workers. The problem is the PRO Act, like AB 5 before it, assumes that everyone wants to be an employee. Many people who work at these companies don't want to work for them, not to mention all the independent truck drivers and freelancers who AB 5 did and the PRO Act would suck up into their socialist utopia of large corporations and unions. While it may not be the intention of the PRO Act, one effect would certainly be to cripple the independent workforce. The PRO Act not so much protects the right of employees to organize, but forces companies to bow to the demands of their unions. Whenever the National Labor Relations Board directs an election under Section 9C or approves an election agreement, the employer of employees in the bargaining unit shall, not later than 2 business days after the board directs such election or approves such election agreement, provide a voter list to a labor organization that has petitioned to represent such employees. With all of the experience we have with government overreach, does anyone really think this legislation will do what its authors claim it will? What we see here is yet another attempt by those in Congress to socialize our society by removing the choice of the individual in favor of the collective. Little concern is given to those who do not wish to collectively bargain or who would prefer to freelance their skills rather than work for someone else. Even less concern is given to the property of the employers that Congress has already taken and wishes to further control. Consider the states where an individual's right to not be forced to join a union is not protected, where people are forced to join a union or in some cases merely to pay dues, even if they don't want the representation. If you are forced to be an employee rather than a freelancer and the state forces you to join a union, are you really free? It really shouldn't surprise anyone that this legislation is named after a union activist. After all, union leaders in bureaucratic states have been leading us hand in hand toward collectivism for decades. As with so many other things, it's not that unions are good or bad, but that they are forced or at least coerced upon the American people. Will Congress ever learn not to exceed its mandates and infringe on the rights of the American people? Well, not until we, the people, start firing those who keep doing so and hire better representation for ourselves. Until then, I suggest you both educate yourself and your state representatives about the limitations of the power of Congress and their responsibility to support the Constitution and protect the American people from all enemies, both foreign and domestic. This type of legislation always seems to be touted as, well, it's for the people, it's for the workers, it's for your own good. What they're really doing is taking away your choice. Whether it's the PRO Act, the Affordable Care Act, or the Inflation Recovery Act, all of these are about taking away an individual's choice, taking away a business owner's choice, taking away their property, their liberty, because government actors think they know better. You will have an election because we say so. You will hold your representatives this way because we say so. And the PRO Act is just the latest in this long line of abuses and usurpations coming out of Congress. What are we going to do about it? I know people laugh when I say we have to hire better representatives, but that ultimately is the answer. Part of the reason I believe we don't hire better representatives is most people, well, they wouldn't know what a good representative is because they haven't studied the Constitution. Well, that's where the Patriots program comes in. The Patriots program is not meant to replace any group or organization you're already in. It's meant to help make it better. It starts with a boot camp where you'll get some basic tools to make sure you have a good, sound argument, tools from the Constitution that you can use to defend your rights. I'm recording a live one July 1st. If you're in Middle Tennessee and you can join us, check it out at constitutionstudy.com/bootcamp. If you can't, don't worry. I'm recording it and it will be available to everybody in a couple of weeks after that. But the boot camp, like a boot camp in the military, is just the beginning. So if you pass the boot camp, you'll be invited to join the Patriots program. This is our 3-lane program to help people, well, be better patriots. The constitutional scholars, where we focus on education. How do we know more about the Constitution? How do we learn about it, use it, and then how do we teach others? The committees of correspondence. How do we have better communication so these different patriot groups don't feel so isolated and alone, where they can find out where they can work together. Maybe not on everything, but they can find common ground to work on different projects together. And then the Minutemen, the men and women ready at a moment's notice to protect the rights of themselves and others, to stand up, to show up, and be that educated person, that buffer, that line in the sand to help defend our rights. Now, if you want to find out more, go to constitutionstudy.com/patriots. Again, you have to go through the boot camp, so you can't quite join it yet, but that's coming soon. But these are all tools meant for you to live a free life. Live at liberty, not as slaves and subjects of an overpowering government. I can't do it for you. No one can. Ultimately, it's up to you. It's up to you to decide how much slavery you'll put up with. What's that line in the sand where your liberty, you won't let it be infringed anymore? I can't answer it for you, and it's going to be different for everybody. But I hope you'll check out the Patriots program. I hope you check out all the work we do at Constitution Study. And I hope you join me here next time and maybe even bring some friends to the Constitution Study.
Love the neighbors and have a few good friends.